and welcome to another episode of Unpacking the Case. I'm joined today once again by our Head of Legal Training here at DJB, Richard Snape. Today we will be taking a second look at some of the cases that Richard touched on in his webinar that took place on Monday, the 21st of June, on commercial lease case law updates for 2021. Richard, it's lovely to see you again. How are you?
I know it's been a long time.
It has. I mean, we did touch base yesterday on our news flash, but it's lovely to see you again, and thank you for joining. So I'll jump straight in. I believe the first case that you wanted to run through was the WH Smith and Commerz case of 2021. Could you tell us a little bit more about the background of that one?
Yeah, it's WH Smith and Commerz Real Investmentgesellschaft. It's a case from this April, and it's only a county court case, so I'd stress that, and they do not set precedents. But it's quite an interesting case and quite a very, very topical case. The background is that it's in the Westfield shopping centre in Shepherd's Bush in London. And WH Smith's large, obviously huge shopping centre. And WH Smith's have a shop there, which also includes a post office. About 16,000 square foot, so pretty big WH Smith. Their lease was from 2008, 10-year lease with a 5-year review. The rent review had taken place in 2013, and the current rent was £953,000 per annum. It was going through a 54-act renewal. There's a couple of issues in relation to it, and I say that's the background, but the first issue was in relation to the terms of a 54-act renewal. They both agreed, both landlord and tenant, Commerz were the landlords, to a 5-year lease for the new lease and not a 10-year lease. Incidentally, I don't think the landlord could have objected to that really. The tenants can't get more than a 15-year lease under a 54-act renewal, but they usually get what they're asking for unless they're asking for longer than the original term. Now, that wasn't really an issue. There were two issues. One, which is perhaps the most important, although they're both quite significant, was the tenant wanted to change the terms and include a rent suspension provision, which didn't just relate to damage and destruction of the property as it already did, but also in relation to pandemics and either statutory requirements or if it was deemed necessary. The WH Smith itself had remained open during the various lockdowns, non-essential retail obviously had to shut down, but as there was a post office in the premises, then they were allowed to remain open, and actually contractually required to remain open. They, however, lost dramatically because the vast majority of the shops in this big centre were closed, and there was much reduced footfall. And they were claiming that their profits had been reduced by about 90%. They're just there in an otherwise empty shopping centre. And so they wanted to, change the rent suspension provisions. And if any non-essential retail had to shut down, even if they remained open, they wanted to have the rent suspended. The landlord was actually happy, I'm not sure happy is the right word actually, but the landlord was happy to reduce the rent by 50% if there was a statutory requirement to suspend, to shut down. But all other obligations like service charge liability would remain. And that was the main item for the dispute. Now, it goes to Section 35 of the 54 Landlord and Tenant Act, which basically says, in terms of deciding the terms of the new tenancy, you should have regard to the terms of the current tenancy. The major case in the past is a case called the City of London Real Property Company, a House of Lords case as it was back in 1983, which says many things, but the major judgment, Lord Wilberforce, says that the starting point is the old lease is the basis of the new lease. It's the person wanting to change the terms who has to show a reason for changing the terms, and things like a change to the rental is not necessarily conclusive. If there's a term that's obsolete or deficient, then they'll change the terms. Otherwise, they have got to strike a balance, what's fair and reasonable between the parties, but the starting point is the terms remain the same. The court decided that because of the current climate, a year and a half, 2 years ago, people just didn't include rent suspension provisions in relation to pandemic as opposed to damage or destruction of the premises. But with coronavirus, that's all changed, and the large majority of new leases are including such provisions. And for that reason, the court decided this was the industry norm, and the tenant had their way. The rent and service charge liability would be suspended, not just if the WH Smiths had to shut down through statute or because of sort of health concerns, but any non-essential retail had to shut down. So that was the first part of it.
Okay, and so what was the second part of that case?
Well, you always have to decide the terms. And I do stress again, I probably should have stressed that that case depends to a large extent on its facts, that this was a large shopping centre where large WH Smiths was somewhat buried and the rest of the shop shut down. It doesn't necessarily follow that it would apply to other premises. And again, I do stress it's only a county court decision and not really a precedent. But once you've decided on the terms, you can go to the next stage and decide what the new rent should be. It's a very good case for valuers to look at. And I can't pretend to know about the valuation implications. But Section 34 of the Landlord and Tenant Act basically says, in the absence of agreement between the parties, you have to decide what's reasonable open market rent with a willing lessor and a willing lessee. And there's various disregards. You disregard the tenant's current occupation, the tenant's goodwill, and any voluntary improvements. It's woefully inadequate, actually, because it goes back to the 1950s, and rent review was barely heard of in the 1950s, obviously moved on a huge amount. Incidentally, the 54 Act the government announced on June the 16th is going to go through major review sometime in the near future. They say by the end of this year, so keep your eyes open on that. But as I mentioned, the current passing rent, based on the rent review of 2013, was £953,000 per annum. Not just because of COVID, but because of what's happened to the market generally. Well, that should go down. The landlord's experts said the new rent should be in excess of £700,000, and the tenant's experts said it should be less than £170,000. That is a heck of a difference between the two people. The court looked at various aspects and comparables, and the fact that there'd been an extension to the Westfield shopping centre, which was meant to be occupied by New Look, who went through a CVA and won't occupy it now. But they decided, and again I'll leave it for the valuers, that the new rent should be £404,666 approximately. And around about 20% of the reduced rent was down to the risk involved for pandemics in the future. Interestingly, the landlord argued there should be an uplift of 10% in the rental because they'd got this rent suspension provision in relation to lockdowns in non-essential retail. The court decided that such rent suspension provisions are now the industry norm, and therefore that will be built into the equation into the rental anyway. And so there was no uplift of 10%. And so you take it as you will, but potentially highly significant. And I'm sure it will be the last case in this particular area.
Wasn't there another case involving Commerz Real Investmentgesellschaft this year?
Yeah, that was the TFS stores case from more or less the same time, actually, which is better news for landlords. It was again involved the Westfield Centre. And TFS, who feature in quite a few cases of late, are the fragrance shop. And they obviously sell fragrances and perfumes in, amongst other places, the Westfield Centre, although they have got shops all over the place. Since the beginning of the lockdown, there's been an inability to, since the beginning of the lockdown, the Coronavirus Act states that you can't forfeit for non-payment of rent commercial property. And that's actually been extended on June the 16th to, from the end of June the 30th this year, it's now been extended to March the 25th, Lady Day next year. And also there's provisions whereby the ability to recover rental through commercial rent arrears recovery is being made sort of massively limited. And that's also been extended to March the 25th next year in England at least. But the legislation doesn't say anything about an inability to sue in debt for non-payment of rent or service charge or whatever it might be. And it doesn't say anything about not being able to claim off guarantors or delve into rent deposits. Since April 2020, TFS, they hadn't paid any of the rental. And the landlord sued them in debt, and the landlord succeeded. I wasn't surprised by the case. It's causing a bit of a stir, but I think it was sort of quite clearly the case. The tenant put forward various arguments, some of which were complete non-starters. There is something called the Code of Practice on the relationships between landlord and tenant during the COVID. It's a government Code of Practice from June of last year. It was actually updated in April of this year. But it is a Code of Practice and it's not legally binding. It's quite clear. And amongst other things under the code, you should cooperate between one another. It was actually held that the landlord had cooperated, the landlord had taken reasonable steps to get this money. And it seemed more that the tenants were not so much unable to pay the rent, but unwilling to pay the rent. And there were other sort of arguments put forward, such as the landlord had taken out insurance for themselves to cover business interruption, which includes pandemics and the likes. And they basically argued that the landlord should have taken out insurance covering the tenant for lost profits and the likes. And the court said there's no such implied term. So that was, quite a clear-cut case as far as I'm concerned, and that's the good news for landlords. I don't think you'd be well advised to go around suing tenants left, right, and centre. And frankly, I'd be very, very reluctant to effect forfeiture for non-payment of rent, even if I could, or for any other reason, not least of which because business creates liability on empty properties when I can't relet after 3 months, in the retail sector at least. So that was the other case, and that's the good thing for the landlord.
Thank you for running us through those, Richard. And I believe another case that you want to discuss was the Criterion Buildings and McKinsey & Co. case that came through again this year. Could you run us through that one, if that's okay, please?
Yeah, that was early in the year, and it follows on from another case I was discussing, Sara and Hossein v. Blacks. And the background to Criterion Buildings, some of you may even know the site. It's Criterion Buildings is on the edge of Piccadilly Circus and backs onto Jermyn Street at the back. Central London. It's got the Criterion Theatre there and the Criterion Restaurant. And also McKinsey have got offices there. McKinsey are an American management consultants who have got sort of businesses all over the world. And they'd agreed a service charge liability. The service charge liability said that the tenants had to pay a due proportion of the service charge. And a due proportion was a fair proportion as determined from time to time by the landlord or their surveyors. And there was no sort of suggestion of reasonableness and the likes. There'd been an ongoing dispute between the parties, been going on for the best part of 6 years, since 2015, and that the tenant was questioning the service charge liability. They were first questioning the allocations and saying that other tenants, basically the Criterion Theatre, have been favoured. They were also questioning reserve funds and landlords' payments towards sinking funds, and whether they were necessary, and also some of the work that had been done. Primarily, as I remember, it was a lift that had been replaced at huge expense, and the tenants were arguing that it didn't need to be replaced. It still had some life expectancy left to it. And that was the background case. It is a High Court case. And the court decided that that provision, you pay a fair proportion as determined by the landlord or their surveyors, was quite clear-cut. In the absence of something like fraud or irregularity, which they were prepared to imply into that, then you would have to pay what the landlord had said you have to pay. There's no ability to question outside fraud or irregularity. And that's a very, very common clause that you'll see.
And there was a similar case that you were mentioning on service charge, and that was Sara and Hossein Asset Holdings and Black Outdoor Retail, and I think that came through last year.
Yeah, they're both of these cases sort of either side, a couple of months either side of Christmas. This is a Court of Appeal case, and Blacks are, the outdoor clothing people, and this was in central Liverpool, the Blacks in central Liverpool. And suffice to say, again, it's about service charge, contested service charges over a period of 2 years here. Not quite the same level of potential liability. The Criterion buildings, they were claiming £2.2 million plus interest service charge liability. This was not quite in that kind of domain. But the tenants were questioning that whether various works that have been done could be added to the service charge in the first place. The service charge provision said that in the absence of manifest or mathematical error or fraud, the landlord's certificate would be conclusive as the relation to the service charge liability. Again, something you see on a not irregular basis, some variation of that. And the court decided, the Court of Appeal, that means what it says. It's conclusive. And you can't question either the itemized statement or the total amount. The Criterion Buildings case, and this, although not as directly, stated really that the test is a subjective one. If the landlord subjectively believes that that is your liability, that's your liability.
And what should tenants do about that, Richard?
Well, obviously, there's a problem with all those existing leases that have got that provision. I think new leases tenants can start thinking about a reasonableness test. There's an implied reasonableness test. If you're dealing with residential service charge liability, there's no statutory control of commercial properties. So you might just think about reasonableness test and the potential for adjudication. It's suggested also that you might make the service charge liability not subjective but objective, with the tenant being the one with the burden to show that this is not objectively a good service charge. You'll certainly need to sit down with landlords and surveyors and tenant surveyors and the likes and think about clearly what is within and what outside the service charge liability. Especially in a case like Criterion Buildings, is think carefully about caps on service charge liability. And again, I'll leave to the surveyors the details of that. Or fixed service charge liability if you think it's appropriate.
And there was one more case that you wanted to run through that you weren't able to mention in the webinar, I believe, and that was Wigan Borough Council and Scullendale Global Limited of 2021. Could you tell us a little bit more about that?
It was a case I put in the notes, but it wasn't something that was advertised on the flyer, and it is a case when it was brand new back in May. I did mention when I did a break clauses course, video conference. It's important in its own context, especially for people like local authorities. It was a late Georgian stately home in Wigan called Hague Hall. And the council owned the site. It had been gifted to them sometime in the post-war years. And they owned this site. They granted a 199-year lease to Scullendale at a premium of £400,000. And they had a break clause. Scullendale were meant to convert the premises into a 4-star type hotel, which would also be a wedding venue. And they had to have 30 rooms in this hotel, and the roof was going to be a sort of a room suitable for weddings and the likes to be held. And they had a break clause which basically said that if you didn't within 2 years comply with the planning permissions, then the landlords had the ability to break the lease and bring it to an end on 2 months' notice. at any time. So it's sort of rolling break in favour of the landlord. The lease was entered into on May the 23rd, 2016, so the second anniversary was May the 23rd, 2018, and they hadn't complied with the planning permission. It was a grade 2-star listed building, and Wigan's planning authority were kicking up a fuss about various things, although they did have planning permission, I do stress. They didn't do anything. Wigan didn't do anything about this until September of 2019, 14 months later, when they gave 2 months notice, terminated in November. And Scullendale argued that you can't do this because you've sat on this for 16 months without doing anything. It's too late. And the court decided on the wording that it isn't too late. It says that you can serve 2 months notice at any time. They did limit it. It's incredibly, I mean, I don't know why they accepted that as a matter of drafting in the first place, because on the face of it, it looks like, during the next 199 years, you can give 2 months notice at any time. They limited it to during the time of the breach. You can serve at least 2 months notice, but as the breach was still occurring, then you could still give notice. And the Borough Council, the landlords won. They dealt with the fact that, well, amongst other things, Scullendale were arguing, well, it's Wigan Borough Council's fault that we haven't completed on time because their planners are kicking up a fuss. And interestingly, the court said that Wigan Borough Council, as the landlord under lease, are a totally different entity than Wigan Borough Council Planning Authority, and that didn't matter. They also said that the court would be prepared to imply a term that you could serve as a tenant a trigger notice, making time of the essence, and that would be implied. It wasn't all doom and gloom for Scullendale. They had the ability, if the lease was terminated by the landlords, of either getting compensation at market value or getting the premium plus the value of any improvements paid back. And I suspect they'll be getting the market value compensation. Ended a bit abruptly, and I suspect they'll be claiming market value compensation. But it is a word of warning in terms of breaks generally, that you have to get the wording correct. And it's a case that perhaps should never have arisen. Okay, and that's it, Hannah.
Perfect. Well, I think that's a great place to end this here, Richard. Once again, thank you so much for your time. It's a pleasure as always.
Right, thank you.
And to all of our listeners, I hope you enjoyed this episode of Unpacking the Case as much as we did.